Assalamu alaikum and welcome back to our channel, True Courtroom Stories. Before we jump in, if you're new here or a returning viewer, please take a moment to subscribe to our channel. And don't forget to like this video and share it with your friends. We truly appreciate your support. This is episode 86, researched by the incredible Mr. Zahir Ahmad Mir, and today we're diving deep into a topic that sits at the very heart of the legal world, the lying witness. You see, truth is supposed to be the most fundamental pillar of any justice system. It's the bedrock everything else is built on. But what happens when that pillar is deliberately shattered? In this explainer, we're going to explore why a lie in the courtroom isn't just a simple falsehood. It's a profound, dangerous crime against justice itself. So let me start by asking you a question, something to really chew on as we go through this. Is a liar more dangerous than a thief? Now, on the surface, you might think, well, a thief steals my stuff, that's a direct harm. But the answer to this question has actually echoed through courtrooms for centuries, and it reveals a whole lot about what we truly value or should value as a society when it comes to law and order. Okay, so let's get into the heart of it. You know, some crimes are committed against a person. A robbery, an assault, those are attacks on an individual. But there's another category of crime, and these are seen as an attack on the very fabric of society itself. Perjury, that is, lying under oath, is one of the most serious of those crimes. To really understand why, to grasp the sheer weight of it, we need to travel back in time. I want you to picture this. We're in the Mamluk Sultanate, maybe the 13th or 14th century. A renowned and respected judge, Qadi Ibn Jama, is presiding over what seems like a standard property dispute. But there's a huge problem. A key witness takes the stand, and their story, well, it keeps changing. It twists and turns with each retelling of the events. Now, the Qadi is sharp. He immediately recognizes this isn't just someone who's confused or has a bad memory. No, this is something far more sinister. He sees it as a direct assault on the integrity of the proceedings right there in his courtroom. The Qadi's analysis of what was happening was, frankly, brilliant and incredibly sharp. He didn't just see a simple lie. He broke it down. First, he concluded that the testimony was intentionally, deliberately fabricated. This wasn't a mistake. Second, he realized the witness was actively trying to destroy someone's legal rights to their property. But it's this third point that is absolutely crucial, the one that elevates this from a simple case to a foundational legal moment. He understood that this single act, this one person's lie, threatened the credibility of the entire justice system. Because if you can't trust what's said in court, what can you trust? So what the Qadi did next wasn't just about handing down a ruling in one specific case. No, it became a powerful, historic precedent. What he did was a moment of judicial integrity enforcement that was, and I mean this, centuries ahead of its time. He wasn't just solving a problem, he was protecting the future of his court. His judgment was methodical, a four-step process designed not just to punish the liar, but to protect the system from ever being poisoned by him again. First, he permanently disqualified the witness, not just for this case, forever. Second, he completely annulled the false testimony, striking it from the record as if it never happened. Third, he fined the man for disrupting the court's proceedings. And fourth, and this is a fascinating move, he publicly listed the man's name in something called the Register of Unreliable Witnesses. Think about that. It was a public list ensuring that this person could never again corrupt another case, because every other judge would know his name. And this brings us right back to that question I asked at the very beginning. And here we have the Qadi's own powerful, timeless answer. He declared a lying witness is more dangerous than a thief. And his reasoning is just crystal clear. Why? Because as he says, a thief steals property once, but a perjurer steals justice forever. A thief takes your belongings, a loss that, in theory, can be recovered or replaced, but a perjurer steals justice itself. They corrupt the very mechanism designed to protect us. And that damage, that loss of faith, can be permanent. Now, that was the 14th century. It's easy to hear that and think, okay, that's an interesting historical curiosity, a story from the past. But what if I told you that the principle the Qadi established all those hundreds of years ago is in fact a vital cornerstone of modern law all around the world today? Let's fast forward. Jump ahead about 700 years from the time of the Qadi. We find ourselves in a completely different country, a different continent, a different legal system. But the fundamental problem of a witness getting up and lying under oath, it remains exactly the same. The challenge is timeless. The parallel here is absolutely striking. Just look at this. On the left, you have the Mamluk Qaji's core principle from the 1300s: perjury threatens the entire justice system. And on the right, that's the United States Supreme Court in the 1973 case, Braunston v. United States. And what was their conclusion? Their finding is nearly identical. Truthful testimony is the very foundation of justice. That connection across 7 centuries and thousands of miles is just incredible. Let's just pause on that quote for a second, because its source is what makes it so incredibly significant. This wasn't just some philosophical debate in a university classroom. This was a landmark ruling from the highest court in the United States. They were stating in no uncertain terms that without truth, the entire framework of American justice simply cannot function. It would crumble. And this powerful principle isn't just limited to one hemisphere or one culture. Let's travel again and look at another major legal system, this time in Pakistan. And what do we find? We find the very same idea being fiercely and consistently defended by its highest court. The Supreme Court of Pakistan has repeatedly, case after case, emphasized these exact points. First, that perjury destroys the court's credibility. Second, that false testimony absolutely must be punished. There can be no tolerance for it. And now look at that last point. Habitual liars cannot remain on witness rolls. Does that sound familiar? It should. It is the modern-day equivalent of Qadi Ibn Jama's Register of Unreliable Witnesses. It's the same logic, the same protective measure, separated by centuries. And here we have this powerful, bluntly honest quote from Justice Qazi Fayaz Issa of the Pakistani Supreme Court. He gets right to the practical heart of the matter. He argues that a justice system simply cannot function if witnesses do not fear the consequences of lying. It's not just a moral principle, you see, it's a functional necessity. For justice to work at all, there has to be a real, tangible reason not to lie. Okay, so we've looked at 3 very distinct examples. From the Mamluk Sultanate, from the United States, and from Pakistan. They're separated by time, geography, and culture. So what connects them? How can these different systems arrive at the same conclusion? It's because they all share a universal legal foundation, a core belief about the very nature and purpose of justice. In legal terms, there's a name for this. It's called the ratio decidendi. Now, it's a Latin phrase, but the concept is actually pretty simple. It means the reason for the decision. It's not just the final verdict, guilty or not guilty. It's the essential legal principle, the core reasoning that the entire judgment is built upon. It's the why behind the ruling. And this is the ratio decidendi, the core principle that unites all 3 of our examples across time and space. The idea is this: testimony is held as sacred. It has to be. Therefore, a falsehood, a lie told in court, isn't just a misstatement of fact. It's viewed as an attack on the entire legal order. It's a crime against society itself. So, what's the ultimate takeaway here? Why have we traced this single, powerful idea through hundreds of years of history? It's because the relationship between justice and truth isn't some abstract philosophical concept. It is the absolute, non-negotiable bedrock of a functioning and fair society. Everything depends on it. I want to leave you with this one final thought, something to really let sink in. A courtroom is more than just a room with a judge and lawyers. It's a crucible. It's where a society's commitment to truth is tested every single day. And as history has shown us, from the courts of the Mamluks to the highest courts of today, when truth is allowed to die in that room, something much
property or causing physical harm. No, this crime is an attack on something much, much bigger. It's an attack on the very foundation of justice itself. So, let's get into it. I want you to just let that sink in for a moment. This ancient declaration is really the soul of our discussion today. Think about it. A thief steals your property, and yeah, that's terrible. But maybe you get it back, maybe insurance covers it. But a perjurer, a person who lies under oath, they steal something you can never get back. They steal the very possibility of a fair outcome. They steal justice itself, and that theft is permanent. This isn't just a dramatic quote, it's a core legal principle that we're about to see echoed across centuries and
So, what really elevates a simple lie into a crime against all of society? We're taught from a young age not to lie, right? We think of it as a personal, moral failing. But the moment that lie is told under oath in a courtroom, well, it transforms into something far more dangerous.
And here's the key. The source material defines perjury not just as a crime, but as a form of social corruption. That's a really powerful way to frame it, isn't it? It's not just one person being dishonest. It's like a poison that seeps into the foundations of the entire judicial process. If a judge or a jury can't trust the words spoken in court, if they can't believe the testimony given under oath, then the whole system just breaks down. The trust, the credibility, it all begins to crumble. To really grasp how seriously this threat has been taken throughout history, we're going to do a little time traveling. Let's head all the way back to 14th century Mamluk Egypt. It might seem like a world away, but a judge back then set a precedent for dealing with false witnesses that is so powerful, its logic still holds up today. This isn't just a history lesson, it's a masterclass in how to protect the integrity of a court.
So the scene is a courtroom, and the case is a pretty standard property dispute. But the judge, a man named Qadi Ibn Jama, was incredibly sharp. He listened to a witness's testimony and sensed that something was deeply wrong. He saw past the surface-level story and recognized the inconsistencies. He realized this wasn't just a case of someone being confused or misremembering. No, he concluded that this testimony was intentionally and maliciously fabricated. And its goal wasn't just to win the case, but to actively and deliberately destroy the legitimate rights of another person. The court was being used as a weapon.
And the Qadi's response to this? It was absolutely brilliant. It was swift, it was severe, and most importantly, it was systemic. Let's break it down. First, he didn't just disqualify the witness from this case, he disqualified him permanently, a lifetime ban. The court was basically saying, you have proven you cannot be trusted with the truth, so you have lost the privilege of ever speaking here again. Second, he immediately annulled the false testimony. He made sure that the poison was removed from the record so it couldn't do any more damage. Third, he fined the man. But get this, the fine wasn't for the lie itself. It was for disrupting the function of the court. He was punishing the man for wasting the court's time and undermining its process. He was protecting the institution. And fourth, and this is just fascinating, he ordered the man's name to be publicly listed in a register of unreliable witnesses. Think of it as a permanent public record, a warning to all future courts and judges. This wasn't just about punishment. It was about building a stronger, more resilient judicial system for the future.
Okay, now let's hit the fast-forward button and leap ahead 700 years, all the way to the modern United States. You'd think that the legal world of a 14th century Mamluk court and the 20th century U.S. Supreme Court would be planets apart, but you're about to see how the exact same core principle, the sanctity of truth, is defended with just as much passion.
In a really famous 1973 case called Bronston v. United States, the Supreme Court had to draw a very fine line. They made a crucial distinction. They said, look, if someone gives a clever, evasive, or misleading answer that is, on a technical level, literally true, that's not perjury. You can't be prosecuted for being a clever wordsmith. However, if you tell an outright, deliberate lie with the clear intent to mislead the court, that is the absolute definition of perjury. So it really boils down to intent. It's the difference between cunning evasion and an outright intentional falsehood.
And here's the money shot. In that very ruling, the U.S. Supreme Court said this: truthful testimony is the foundation of justice. Just pause and think about that for a second. 700 years after Qadi Ibn Jama created a public shame list for liars in Egypt, the highest court in the United States uses almost the exact same logic. They both came to the same unshakable conclusion. Without truth, the entire building of justice comes crashing down.
Our third and final stop on this journey brings us right into the 21st century, to the modern-day Supreme Court of Pakistan. And as we'll see, the court here has recently taken an incredibly strong and rigorous stance on the problem of false testimony.
Looking at a series of key rulings between 2019 and 2022, Pakistan's highest court has sent a message that is crystal clear. They've affirmed that perjury directly attacks the court's credibility. They've stated that false testimony isn't something that can be punished, it's something that must be punished. And, echoing that Mamluk judge from centuries ago, they've ruled that people who are habitual liars simply cannot be allowed to remain on the official witness rolls. It is a modern-day policy of zero tolerance.
And this quote from Justice Quasi Issa just cuts right to the practical heart of the issue. Why be so strict? He explains it perfectly. It's not about being vindictive, it's about functionality. The system simply cannot work if there are no real consequences for lying under oath. That fear of punishment isn't just about getting revenge. It's a necessary deterrent that makes the whole process of finding the truth even possible.
So we visited a 14th century Mamluk court, the 20th century U.S. Supreme Court, and the 21st century Supreme Court of Pakistan. We're talking about vastly different cultures, different eras, and different legal systems. And yet, as we've seen, they are all connected by a single, beautiful, golden thread, a universal truth about justice.
In law, there's a concept called the ratio decidendi. It's a Latin phrase that basically means the reason for the decision. It's the core principle that a whole ruling is built on. And the ratio decidendi for everything we've talked about today is this: testimony is sacred. It's not just idle chatter. It's a solemn promise made to the court and to society. And because it's sacred, a falsehood told in that context isn't just a simple lie. It's a fundamental crime against the entire legal order, an attack on the very system that society creates to maintain fairness and peace. We've seen today that for hundreds of years, the wisest legal minds have known that justice is completely dependent on truth. So that leaves us with one final and, I think, pretty heavy question to consider. If truth is allowed to die in the one place where it is sworn to be sacred, the courtroom, what then dies in the